and the defendant shall rise. In cause number 23 CR1, the state of Texas versus Faisal Atari, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of...
Welcome back to Court Reacts. What you just heard is a jury four-persons verdict being read out loud in Jefferson County, Texas. This is the punishment phase. The guilt question was already settled. The jury found Faisal Atan guilty of a third-degree felony, assault family violence by choking. Now, the same jury decides how many years. We're going to ride through the whole 12 minutes, the verdict, the judge thanking the jury, and the formal sentence. Heads up, this one involves domestic violence, so I'm keeping it sober. Let's start at the case call.
Okay, we're at? Yep. We now recall cause number 23 CR1, the state of Texas versus Faisal Atari. The defendant is present with his attorney and the state's attorneys. The court has received a message from the jury that the jury has reached a verdict in the punishment phase of this trial after the defendant was found guilty of the third-degree felony of family assault by choking. And I'm going to ask the bailiff to bring forth the jury.
Right there, Judge Stevens lays out the whole posture in one breath. Cause number 23 CR1, State of Texas versus Faisal Atan, defendant present with his attorney, and the court has already gotten word the jury reached a verdict in the punishment phase. That word punishment is the tell. Guilt is done. A jury already convicted him of family assault by choking. The only thing left to decide is the sentence, and they're bringing the jury back in to deliver it.
And the record shall now show that the jury is in the courtroom. All parties are present. Mr. Kirkendall, I believe you are the jury foreperson, and we have received a message on the jury's behalf that the jury has reached a verdict in this punishment phase of this trial. Is that true, sir?
Yes.
Is this decision a unanimous one? That is one that is agreed upon by all members of the jury? And do any of the jurors disagree with your foreman's representations? No disagreement is indicated. It does indeed appear to be unanimous. As before, I'm going to ask, please pass to the bailiff.
This is the part people don't see on the highlight reels. The judge confirming the verdict is real and unanimous before he reads a single number. He IDs the foreperson, Mr. Kirkendall, asks if they reached a verdict, asks if it's unanimous, and specifically asks if any juror disagrees. Nobody does. That matters. In Texas, a punishment verdict has to be agreed on by all 12. He's papering the record clean so this holds up. Then he says he'll review it for proper form and publish it. Now the defendant rises.
And the defendant shall rise. In cause number 23 CR1, the state of Texas versus Faisal Atari, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 5 years, signed by the jury foreperson. This verdict is received. It's made a part of the record for all purposes, and you may be seated.
There it is. We, the jury, assess the defendant's punishment at confinement in the Texas Department of Criminal Justice for a term of 5 years. 5 years. For context, a third-degree felony in Texas carries 2 to 10. So the jury landed in the middle, not the floor, not the cap. They heard the evidence on a choking case, a strangulation allegation, and they came back at 5. The judge receives it, makes it part of the record for all purposes, and tells him he can be seated. Conviction plus sentence locked in.
Ladies and gentlemen of the jury, your duty is complete. At the beginning of the trial, I placed you under a number of instructions, and at this time, I am releasing you from those instructions previously given to you. One final instruction, though: once you are discharged, you are released from your oaths of secrecy, and you will be free to discuss the case in your deliberations with anyone. And you are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by the court. Once you are discharged, in a few minutes, the attorneys are going to be released, and they always like to talk to jurors about how they did and the jurors' perceptions. And if you wish to remain, and we're going to be releasing them here in a few minutes, they always found that helpful. But you are also free to go.
Now Stevens shifts into the part he clearly cares about, releasing the jury from their oath of secrecy and thanking them. And listen, this is a recurring Stevens move. He turns a routine discharge into a civics lesson. He tells them their duty is complete. They're free to talk to the attorneys or stay silent, free to go enjoy the rest of their lives. Some judges mumble through this. He treats jury service like the load-bearing beam of the whole system.
And enjoy the rest of your life outside of this courtroom. I can't say enough about thanking you for your time and energy, and as being jurors. And we're coming up to a very important point in time in this country, our 250th anniversary of our independence. And part of that independence was the belief that our forefathers had that we, the people, should be making decisions, not those who were kings or other emperors, but that we, the people, together, and that the decisions would be made. All of us having a voice, an equal voice, and fairness would be part of the equation. So I want to thank you for your time and energy. It's up to you to be here so that the Constitution will work. And it's just not words. You are making those words into action by your efforts as jurors. So thank you so much for your time. And
he ties it straight to the country's 250th anniversary. The idea that we, the people, make the decisions, not kings, not emperors, and that fairness is part of the equation. Whether or not that speech is your thing, the underlying point is real. 12 strangers, not the judge, set this man's sentence. The judge can't override it. That's the design. He's telling them the Constitution only works because they showed up.
Energy. And like I said, this is like 615 felony jury trial we've tried in this room since I've been here, which I think is a world record. But in other facets of my career, from the DA's office to private practice to the United States Attorney's Office, and to here, I can guarantee you that it's how people handle the jobs when we are called upon. And as I said, I had the experience in the James Byrd cases, which there were more microwave trucks around the Jasper courthouse than you can imagine, because everybody in the world was looking at how that would end up. Would our laws work, and would justice be served? And this isn't going to get the kind of press coverage like that case, but it is so important to everybody involved: the defendant, the state, the people, the victim, and others involved. So these are important, and we, the people, get to make those decisions, and it's up to us to make fair decisions as you follow your oath. I hope to have the honor to work with you in the future. Until then, though, may God continue to bless Jefferson County and her citizens, and you are excused. And thank you, alternates, for being with us through this. Thank you for holding vigil.
And here's the Stevens flex. He says this is roughly the 615th jury trial in this room since he's been on the bench, which he figures might be a world record. Then he reaches back to the James Byrd cases in Jasper, when, his words, there were more microwave trucks around the courthouse than you can imagine because the whole world was watching to see if the laws would work. His point: this case won't get that press, but it matters just as much to everyone involved: the defendant, the state, the victim. He thanks them for holding vigil and excuses them.
Is there any reason why formal assessment of punishment not be made at this time?
No, Your Honor.
Faisal Atari, you came before this court and a jury entered a plea of not guilty to the offense of the third-degree felony of assault, family violence by choking as set forth in the indictment. The evidence was presented. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this third-degree felony of assault, family violence, and assessed your punishment at confinement in the institutional division of the Texas Department of Criminal Justice, prison, for a term of 5.
Jury's gone, and now the judge does the formal part himself. He recites the whole record back. Faisal Atten came before this court, pleaded not guilty to the third-degree felony of assault, family violence by choking. The evidence was presented. The jury was charged, and after deliberating, the jury returned a verdict finding him guilty and assessed 5 years. He asked both sides if there's any legal reason sentence shouldn't be pronounced. Defense says no. This is the moment the jury's number becomes a court order.
5 years. It is therefore the judgment of this court that you are guilty in this cause number 23 CR1, and you shall be punished in accordance with the jury's verdict. On behalf of the defense, Mr. West, is there any legal reason why sentence should not now be pronounced against the defendant?
No, Your Honor.
If nothing is left to be said, it is the order of the court that you, Faisal Attari, who has been adjudged guilty of the offense of assault, family violence by choking, a felony, third-degree felony in this case, in cause number 23 CR1, and whose punishment has been assessed at 5 years imprisonment in the Texas Department of Criminal Justice's Institutional Division, prison, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 5 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the Sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence will commence or begin this day, and you will receive credit for all time periods of detention that you have served as provided by law. Anything else to add by the state?
No, Your Honor.
Defense?
No, Your Honor.
These proceedings are therefore concluded, and we are in recess.
And he pronounces it. A judge guilty of assault, family violence by choking, a third-degree felony. Punishment assessed at 5 years to be delivered to the Texas Department of Criminal Justice. Sentence commences today with credit for time already served. He confirms nothing's left to add from the state or defense. Then, quietly, these proceedings are concluded. We are in recess, and he calls the next case. No drama, no speech for the defendant, just the machine finishing its work. A jury heard a strangulation case, convicted, and handed down 5 years. So that's the whole arc. Guilty verdict already in. Jury assesses 5 years on a family violence choking felony. Judge makes it official. Next case. Quick note on the care side. I'm not naming the protected party, and I'm keeping the edge where it belongs on the conduct and the sentence. If you or someone you know is dealing with domestic violence, the National Domestic Violence Hotline is open 24/7 at 1-800-799-7233. If this breakdown helped you understand how a punishment phase verdict actually works, subscribe to Court Reacts. We go through these the whole way, beginning to end. I'll see you in the next one.